Hello, I'm Professor Donna Byrne from William Mitchell College of Law, and this is Estates and Trusts online module about trustee duties and powers. Who are trustees? When you think about these materials, ask yourself, why did we choose this trustee? Would I want to be this trustee? Would somebody else have been a better choice? How did this situation occur? Because you'll find that it's really easy to point fingers, but it's also relatively easy, or appears to be, to end up in these messy situations. So our objectives for this module are to describe the trustee's duty of loyalty and identify some situations where issues about that duty arise, to explain why self-dealing breaches the duty of loyalty, to identify acceptable alternatives to self-dealing, and to explain how a duty of impartiality is also part of that duty of loyalty. And finally, we will begin to explore the Uniform Trust Code. We've looked at the Uniform Probate Code. We have some provisions this time from the Uniform Trust Code. Okay, so we'll talk about the estate of Hines to kind of zoom in on this duty of loyalty. Charles Hines died and left the family home to his wife for life and the remainder to their 3 children, William, Marjorie, and Sally. Now, William died next, predeceased his mother, and left his interest in the property to his children, Karen and Gary. I've drawn a little family tree there. Marjorie assigned part of her interest, 1/10 of her interest, to her daughter, Tanya. So you could identify all of these interests. William, Marjorie, and Sally have remainders. William died, so Karen and Gary each inherited half of his remainder, as did Tanya. So here's what it is. Ruth for life, that's the mother, and then 1/3 to Sally, 1/6 each to Karen and Gary, and 1/30th to Tanya and 9/30ths to Marjorie. And you'll see that those 30ths add up to 1/3. All right. Now, what happens? Karen, the granddaughter, is appointed personal representative. So she's the one who has to be responsible. Now, before you point fingers at Karen, think about yourself and your family. Are you the only lawyer? A lot of times we're the only lawyer. We're the person with the most education, the expertise closest to this. We're the ones that the family is likely to choose as the personal representative or the executor. Okay, so what do we have in the estate? We have a house. And Marjorie wants to buy it. That's good. So Karen, the PR, is happy to sell the house to Aunt Marjorie. They negotiate a sales price. They negotiate who's to pay the closing costs and even the time period within which the buyer, Marjorie, has to get financing. This sounds very professional, doesn't it? Marjorie, however, can't get financing. And a year goes by. So they only get one other offer in all that time, and finally Karen and her brother Gary decide to buy the house themselves. Now, you should go back to the casebook and look at the terms of their deal and compare them to the terms of Marjorie's deal. It's not exactly the same, but they're not that far off. But now Karen is in trouble. As you can imagine, Marjorie is not very pleased, especially because she wasn't informed. Did Karen and Gary pay a reasonably fair price for the house? They did. They paid a fair price. It may have been a little bit lower, but we all know that prices go up and down. So what's the problem? Is it the price? Is it not telling Marjorie? If you were one of the relatives and found out that Karen and Gary had bought the house, would that bother you, assuming they paid a fair price? Well, here are some quotes from the case. The law prohibits a party from purchasing on his own account that which his duty or trust requires him to sell on account of another. He is not allowed to unite the two opposite characters of buyer and seller. There's a conflict of interest here. Karen as the PR is the seller, and Karen as the buyer, as the purchaser, is the buyer. We can't be both sides of the deal. Not when we are a fiduciary for other people. So she has a conflict of interest. Now, based on this quote, does it matter what price she paid? Based on this, she could have overpaid. and it still would have been self-dealing and wrong. Now, what do? I mean, what if there are no other buyers? Karen and Gary are willing to buy the house. Everybody agrees we think it's a good idea. What could they do? Get court approval. That's the main thing. Get court approval. And that's going to mean that you will notify the other beneficiaries. But really, get court approval. She did try to get approval, but it was after the fact. Nunc pro tunc. That means now for then. And that's not the way to go about it. Are there some exceptions to this? Now, trustees are compensated for their services. So that would seem to create a bit of a conflict, but nobody seems to mind that one. Should the no further inquiry rule, we're not even going to ask if the price is fair, should that rule be relaxed? All right, that's the rule that says we don't care whether the price is good. Self-dealing is just automatically wrong. What if the trustee sells to a close relative, not to herself? Okay, so that was the duty of loyalty, no self-dealing. Self-dealing is bad. There's also a duty of impartiality, and that means that you have to treat all of the beneficiaries equally, or at least equitably. And sometimes that means some tension between the income beneficiary and the remainder beneficiary. We'll see that come up some more in a couple more videos. All right, this is one of the problems. I'm going to take myself out of it. You work in a trust department of a regional bank, which has branches in a number of small communities, including your hometown, where the bank is currently serving as executor of the estate of a prominent citizen. You are assigned to supervise an estate sale of the decedent's tangible personal property, right? The stuff. So, in that role, can you sell to your spouse? Can you sell to your mother? Can you sell to your best friend? Post your thoughts about this on Blackboard. All right, how close is too close? How close counts as self-dealing? When you represent the fiduciary, do you also represent the beneficiaries? Sometimes with estates, it's not that clear who your client is, because we've got the estate, we've got the executor as an individual person, and then there's one or more beneficiaries. Read the Gadsden article on pages 595 and 596, and then also note I, or maybe that's a note 1. And think about whether you agree with the court's reasons in Trask versus Butler. I'm not going to tell you what this is. Read the statute also on page 597 in note 3 about personal representatives. It tells you that a beneficiary of the state should not be treated as a client. But what does that mean as a practical matter? And keep in mind that a lot of times the executor is a beneficiary of the estate, but likely not to be the only one. Okay, we said we'd talk a little bit about the Uniform Trust Code. Your casebook has several code sections that lay out a trustee's powers. Now, it's kind of tedious just reading through these. So what you want to do is take one or two of those provisions and then try to set the words to the tune of a well-known holiday song. And then we will all sing these songs at the beginning of the next class. Or you could record yourself and post the results on YouTube, and then I can post them on our class website. Now, if you go back to the PowerPoint, there's a delightful example of what I'm asking you to do, or something similar, here on YouTube. This is from the movie Born Yesterday. Okay, final question. I think this is a final question. Who should be the trustee? Who would you choose? Now think about Karen and Gary, right? Karen was the personal representative. She was a granddaughter. That means she's going to have to go up against her Aunt Marjorie and who was the other one? Aunt Sally. Is that putting her in a reasonably okay position, or is that going to be problematic? Who would you choose to be executor of your will or administrator of your estate, and why? We're going to revisit these questions. I'm going to keep reminding you to ask these as we see the kinds of sticky positions that trustees seem to get into. Okay, so let's summarize. Where have we been? Fiduciaries, and when we talk about trustees, we could just as well be talking about executors. It's kind of the same role. You're managing property for the benefit of other people. They have to avoid conflicts of interest, and obviously it's easy to say that, but sometimes these conflicts come up in unexpected ways. Generally, though, self-dealing is absolutely forbidden, right? We saw that, even if the terms are favorable. In addition to that, there's also a duty to be impartial. We'll see where that comes up a little bit later. And the Uniform Trust Code, if you did take a look at it, can help answer some of those questions. It tells you how to allocate things. It tells you who to treat as a client, and so on. Yeah, this has nothing to do with anything whatsoever. These are hedgehoglets. Thank you for watching.